make a call to your friend. Yes, serve the copy, sir. Already serve చేస్తారండి మీ క్లర్క్ ని అడగండి. ఆయన కూడా పడేసి ఉంటాడు. Item number 1. నీ ఆడ పడతావు అన్ని. Go and make a call to your friend. Yes, sir. Yes, senior.
Before I take your lordship to the second question which has been filed, I understand on the last occasion they made an objection saying that the matter will have to go before the central tribunal. That seems to be the objection which has been raised in this regard, my lord, as filed for the counter appeal. Controversy in this is, my lord, as your lordship is aware, there is an act called Apprentice Act. And under that, my lord, persons who have completed 10th class, persons who have completed ITA, both of them can get trained as an apprentice in various institutions. After the examination, my lord, there was a trade test that was conducted, which was of 100 marks a theory paper, followed by a practical examination 300, which was supposed to be awarded by the institution under which I was getting apprenticeship, and there is a sessional marks for 20 or 15 also. Now 300 plus 4 examination was what was supposed to be taken, and when the employment was supposed to be given by the concerned organization, preference or weightage is given to persons who did the act apprentice in the particular organization. This is the scheme. Now in the instant case, what happened, my lord, persons before your lordship who are petitioners are those who wrote the written examination as well as practical examination, and they are aggrieved by the order passed by the Director General of Training, which your lordship gets at page 85. This is their grievance. 25th January 2022, page 85 is one of the orders that have been improved. Kindly see what it has said. What it says. Reference to office memorandums issued by Ministry of Skill Development and Entrepreneurship for the simplification of the process in the apprenticeship training, it is informed that the ITI passed candidates, national trade certificate qualification holders, shall be exempted from trade theory examination to get national apprentice certificate. The results will be declared based on the marks obtained in the practical examination. The order will be effective from 1st January 2022, and it will be applicable retrospectively to ITI passed candidates who have cleared the practical test but not cleared the theory trade examination. Further, the industries engaging apprentices in the designated trades must conduct the practical examination in the last week. This is what it says. So, my lord, by virtue of this, there is a dichotomy of those apprentices who are there. One who wrote the written test and one who did not write the written test. And one who failed the written test will get the benefit of this, and the persons who passed will not get it. Now, what exactly happened in this was they issued a notification saying that we will give certain weightage. Then kindly see the prayer which has been made in this inspection, my lord, at page 20, para 19. Hence it is prayed, I skip all those things, writ of manumus, directing the respondent number 1, that is the Director General of Training, to remove the discrepancies arose by letter dated 25th January and awarding marks based on practical examination, causing injustice to pre-2022 course certified act apprentice candidates, and further direct respondent number 1 to coordinate with respondent number 4. So the main requisition is directed against the DGT. Now in the counter affidavit, the DGT doesn't prefer to file a counter. They filed a vacate petition. Kindly see the vacate petition. Who deposed to this? I am D. Arun Kumar. Kindly see para 1. I am working as a chairman railway recruitment cell, second Rabat, working in the third respondent organization, and I am acquainted with the facts of the case. Kindly see he is deposing only on behalf of himself, not on behalf of the DGP. I beg a question to myself at this stage. Can the railway board, whoever this gentleman is, defend the action of the DGP? The answer can only be no. He has no authorization to justify that 25/1/2022 because
respondent number 3 also, sir. Respondent number 3 also he filed this application.
Yes, we have filed it. But he is not the person who is the author of the 25th January 2022. And this third respondent, if your lordship sees, he is a railway officer. Railway can't defend the DGT's order.
Yes, sir.
Now, what I say is, my lord, once DGT decides it one way or the other, consequential action will have to be on the. Now, what would be the main grievance of the petitioners is like this, my lord. 520 was what I had to secure, persons who passed the examination. 400 is what they will have to secure, who got the exemption by way of 525/2022. Now, a percentage of this is taken for the purpose of weightage when I get an opportunity to get appointed in railways. So, 520% and 400% are not on the level playing field. By virtue of that order, you are making two disproportionate, two persons discriminating among the pre-22 and post-22. And by virtue of that, automatically what happens is, persons who pass the examination will not get employment. And the second reason why they have to say this was, the Bombay Railways Management said, after the introduction of this practical theory, practical examination, the railways has been doling out marks, left, right and center, and in fact some cases 300 out of 300 was also given. Then in the counter affidavit, when we specifically plead that, kindly see how secretive the railway can be. Assuming that they have any right to file a counter defending DGP, kindly see what they have to say in respect of this particular allegation. Kindly straight go to paragraph 10 and page 13. This obviously is in response to the statement and paper where, my lord, the railway said that Bombay region specifically said, we have been observing that they are doling out marks left, right and center. Consequently, the very purpose of having a dispassionate selection is not available. This is specifically my pleading in the reflection. And to this, the author says this. It is submitted that further, the reliance placed by the petitioner on the letter of the SDGM, Western Railway, is also misconceived. The SDGM's letter, your lordship, will get in the material papers which I have filed. At page number, see what 29/4/2025, 98, if I remember. My lord, 1 second, my lord, I'll give you exact. He says that, and for this is the reply. Kindly go to page 86 for one moment, my lord. This is the letter, Churchgate, Mumbai. Kindly go to page 87, para 5. 20% of the direct recruitment, that's how the paragraph begins, my lord. 20% of the direct recruitment at level 1 are done by regional recruitment cells from the candidate who has successfully completed the training from railways. Hence, the marks scored in the examination certificate plays a vital role in getting in the job railways. This gives an opportunity and chances of corruption as candidates are ready to pay through unfair means for getting maximum score in the examination and certification. Because there is no written examination, I say good morning and good afternoon to the officer promptly, I'll get 300 out of 300. This is what the railways itself says. Now kindly say what this man has to say in the counter affidavit. A stray incident, and then concerning one of the units of one of the zonal railways, and necessary corrective action has already been recommended with adherence to the policy decision. The guideline is not even filed. What have you said? How are you going to check it up? Is not there. But because there are vacancies which are liable to be filled, railways is interested only in filling up appointments, and we know for what purpose. Whenever there is an and this objection saying you will have to go to central tribunal has not been taken before this Chief Justice's bench in one of the matters. It was not taken before your lordship in one of the matters. Your lordship have dismissed it because there is an interim order not to go ahead with the process of selection. The railway springs up and tries to defend some other person who is not even the author. My lord, in Hindi there is a saying, my lord, Begane ke shaadi mein Abdullah Diwana. Exactly, this is the case here. There is no English translation for that. Therefore, I will have to borrow. It is somebody's marriage. It is somebody's author. Somebody is the author of the letter. And railway says because it is appointment, I will have to do it. And kindly see, the anxiety seems to be only this. Since you are only agitating against 20% vacancies, why should you have 80%? Why is the anxiety to fill up more than try to wait for and work it out with the DGT? So, the breakneck speed will work. Every train will become a super fast express. My humble submission is only that anxiety. They have not even applied themselves to what is the issue, why they will have to defend it, who will have to defend it. Therefore, my humble submission will be twofold. Number one, this vacancy section doesn't need to be considered by your lordship at all. Second thing is, since my grievance is regarding the DGT, myself going to central tribunal does not arise. Because if I have already got a clearance from DGT and I am trying to get my case considered before the railways, perhaps my lord, his lordship Justice M.N. Rao as the learned judge like was said, it includes appointment also. But that stage has not come here. So therefore, my submission would be twofold, my lord. As I told, this vacancy section need not be considered by this honorable court. First, but only as an alternative without agreeing that this order needs to be modified. At best and at worst, this 20% can't be allowed to be filled. Because even they say, my lord, 80 should not have been stopped. At least substantial chunk of appointment should go on. That seems to be the anxiety rather than anything else.
You are only 15 members. Why you are opposing? Stopping the 20% of appointment. You are only 15 in number.
No. 20% of the posts are reserved for these people. Rest of the 80 will be for general people. So for 20%, act apprentice can get their selection only for 20%. Stalling the entire 100 may not be valid. That's what they say in the counter also. Kindly see that portion of the counter also, my lord, at page number 11, para number 18.
Yes, sir.
It is also brought to the notice of the honorable court that the claim of CCCS and the petitioners in the present case is restricted only after 20% of the total vacancies notified, and to hold back the result of the CBT for remaining CBT is computer-based test, my lord, which they will have to pass for getting appointed. Remaining 80% notified from the publishing would put chances of employment of aspirants for a serious and a severe disadvantage. So, and kindly see, they are trying to say they have been waiting since long. We have also been waiting. But
వాళ్ళు మీకోసం ఎదురు చూస్తారు. వాళ్ళు మీకోసం వేచి ఉన్న నిరీక్షణ.
No, మాకోసం ఎదురు చూడట్లే. ఆ 80% వాళ్ళకి ఇంపార్టెంట్. ఎందుకంటే ఎక్కువ పోస్టులు ఉంటాయి కదా. So therefore that emphasis would be on that. ఇప్పుడు ఫేస్ సేవింగ్ రేస్ అంటే సిన్స్ DGT ఆర్డర్ వాళ్ళు డిపెండ్ చేయలేరు కాబట్టి ఆ 20 ని మేము ముట్టుకోం, పర్వాలేదు. 20% అంటే it's only 100 vacancies. 900 will be easy for us to work out the thing. Railways will move fast. That seems to be the anxiety. But still, your lordship, I have to say only one thing, my lord. Since your lordship were satisfied that the DGT's letter was not proper, your lordship passed an interim order. If the DGT comes before your lordship and says that this is the justification, and if your lordships are satisfied by that, this order can be modified, but not by and at the instance of the railways.
Yes, senior.
I will take the prayer. Page 20. Your lordship has seen the main prayer. I don't know your lordship read it because my friend read it. Para 19. But they are questioning the proceedings of the letter of the DGT dated 25th January 2022. I see the interim prayer sought. Pending disposal of the request. Read that this honorable court is pleased to direct the third respondent and the sealer not to declare the CBDT results pursuant to CEN number so and so and pass such an order. And my respectful submission, the interim prayer sought in the request is neither incidental nor relating to the proceedings which are in question before this court. Secondly, the notification which is at page, which is at the CEN, which is at page number 90, that very important. And they come out to 37. This is the centralized employment notification relating to railways.
Yes, sir.
Number of posts 32,438 throughout the country. This notification is not under challenge. Kindly note that this notification is not under challenge. A interim prayer is sought which has beyond the scope of main relief in the reflection. More particularly when it relates to a notification which stands exclusively within section 14 of the Administrative Tribunal Act, as held by the Constitutional Bench in Chandra Kumar's case. And secondly, we are kindly seeing that this notification is issued 2024 and kindly come over to counter file turned out. A third respondent and this is para 16 of the page 10.
Yes, sir.
It is submitted that to fill up the central the CEL 8 of 24, the employment notification to fill up the same category of the vacancies of 14 departments in railways. Among the vacancies, constables were in social categories. Those are critical for safe operations. It is also submitted the process of recruitment level when vacancies the railways is long run in time and period more than 1.08 crore applicants. Aspirants compete with each other through various stages of examination written test CBT held in 369 centers of 159 cities in 29 states all over India for 4 months. Physical efficiency test of these candidates would be qualified for the CBT equally large proportional so and so. And kindly come over back not to the notification which is at 37.
Yes, sir.
Kindly come over to page 68.
Yes, sir.
Out of that 32,000 vacancies which has been notified in the railway board, these are the about 21 respective regional railways. These posts were distributed. The petitioner before your lordship relates to that one person belongs to he applied to this current region, which is the Chennai and localized. I will just say the petitioner name also. Petitioner number 6. He applied vacancies in Southern Railway, which is headquarters at Chennai. Based on the marks obtained, it applies only to 88 candidates and the candidates who have the national trade certificate qualification. For those candidates, it is not necessary to subject them to class. The results will be declared based on the marks obtained by the practical examination. The order will be effective so and so and will be applicable retrospectively to ITI passed candidates who have been cleared the practical ATT exam but not this so and so. But be that as it is. This you are not to decide that. My respectful submission is that there, as I mentioned, 21 regions in the country notified these vacancies of 32,000 people. More than 84 lakh people have applied. Though 108 applications, 1 crore 8 lakh applications applied. Delhi was made. I then vote also and see. But so far as the and just note this.
Yes.
So far as this Secunderabad railway region where these people applied, the total 1,642 vacancies are notified. And out of that, 9,61,263 candidates applied. And more than 5,28,609 candidates appeared for the examinations on different dates, which were for December 25 and February 26. And my respective submission, a submission had been made by the petitioner. In the event of calculation of the marks, they are saying that some dichotomy between 2022, post 2022. That does not, at this stage, results of the main exam itself are not declared. Kindly come over with the notification. Now, this is not by considering the jurisdiction of the honorable court. It is just to say that there are no prima facie. Kindly come to paragraph 12 of the notification, which is at 57. But this relates to Railway Act apprentices. You not still find that to a paragraph at page 7.
Yes.
Correct? If at all that this notification, if they have any alien, they should have charged before the tribunal at a proper step and the notification. Even this also doesn't come through the disadvantage. It is a clear case of apprehension and NDC 12.4. The course completed act apprentices will be given due weightage for the marks obtained in the National Council vocation test. It says that whatever you got marks in the test will be given due weightage examination, and such that 1/3 of the marks in the preparation of the final merit. So 2/3 will be written examination merit, and 1/3 will be for them merit list. After conduct of CPD shall be based on the marks obtained in the National Council vocation test. The next one is important. In situation where the marks obtained by adding the NCTU score is less than the marks obtained in the CPD, then the higher or best of the two marks will be considered for these people. The course completed apprentice will be exempted from the physical efficiency. The course completed CCA, trade, railway should upload their details of solicitors. The candidate fails to clear the solicitors. My respectable friend, a combined reading of 12.4 and 12.5. What it says is that the note, because we can't do anything now, even tomorrow results are declared. It has to be only strictly in terms of 12.4. 12.4 is not in question before this court. They say that they doesn't read how that is disadvantage to them, except orally saying all these things. But we enjoy not when my friend argues. He puts the question on my behalf, and he also puts the question answer also from his side. We appreciate that argues my friend is having it. But the reason is this one. Combined reading of 12 and because we are bound by the what we said in the notification, assuming for a minute whether it is or not. But my respectful submission in so far as the interim prayer is concerned, totally beyond the scope of main prayer sought in the requisitions. Notification is not under challenge. It cannot be challenged before this court. And they have remedy in the earlier case when the notification has come. But now saying that alternative they want 20 is absolutely, we never agreed for 20. We said you come under 20 category. And that is against 32,000 people. So far as this region is concerned, both and further. I pray that this idea filed by them for interim prayer shall be dismissed. But leave the request main prayer, so far as that is going, we are going to defend it. And the counter had been filed on the third response. He said that because he is the officer railway teacher. Now they included the general railway. But what I respect is they doesn't say that I have seen the list of they doesn't say which region they are from. They can't file here. But seeking this relief, which affects the throughout the country. Exams are over. It has 3 stages for document verification, everything. But I pray that the immediately the interim order.
You pass out.
I have 3 questions of what my learned friend said. My lord is reply to it. I will restrict myself subject to my learned friend completely. My lord, we can prejudice the mind of the court. That's also an art. I will have to learn it from my learned friend. Kindly see that
since I complimented, this is the reverse compliment I have taken from you.
Both will have to
Whether it's a compliment or not, I have to introspect.
Without diluting further,
really
kindly see the first submission. My lord, I will go in the reverse order. See page 57.
I'm sorry, one more aspect.
Yes,
So just wait. My friend had brought the words to 86 also. 96, what letter? In the northern region, it doesn't relate to recruitment. It is at the time of entry as apprentice. Kindly come out there. It can't be connected to any of the issue here. Preventive check of conducted regarding the engagement of apprentices under the Apprenticeship Act. At the time of entry into the, there is a railway board circular. I have seen this letter. There is a railway board circular issued in the year 2015, where they said that whenever they receive the application for apprenticeship, it has to be scrutinized by a committee consisting of so and so officers. And also there is a methodology in that insofar as the processing of the applications for the admission of these apprenticeship. Since those mandate of the tribal board circular has not been complied in those cases, can we just see that it has nothing to do with either the proceedings of 25th January or this one. With reference to that, it stated that the preventive check vigilance has been conducted regarding the engagement of the apprentices under the Apprenticeship Act, engaged in Western regions so and so. The irregularity found during the check period is the merit list candidate should be, as I mentioned, by junior scale committee members prior to so and so. This was not complied there. The second one is also not as per the NDC para 2. Railway Board Circular number so and so state that a merit list would be prepared by committee who will be then place the result before the head of the working shop. So what they requested ultimately, you shall comply with the mandate of the Railway Board Circular when you are considering the applications for the entry into the apprenticeship. We are not in the stage. This is after the 2022 order is in question, for 25th January order. That relates only to ITA candidates and national certificate holders who are specified there. And for after 6 years, they did not solve that order is not under suspension or any interim relating to that is not paid. They want straight away omnibus way of staying the results throughout the country.
Take your lordship to 57 first man. Why we are before your lordship should appreciate that. 12-4. There is some dichotomy. It's not the correct sentence that's liable to be. It is dichotomy. ITC 12-4 once again, madam. The course completed at apprentice will be given due weightage for the marks obtained in the National Vocation Test examination, such that 1/3 of the marks in the preparation of final merit list after CBT shall be based on the marks obtained in the National Vocation Test. Previously, this National Vocation Test comprised of a theory trade paper for 100 and practicals for 300. Now you have done away with that 100 business. So it is only 300 plus sessional training of 100 marks, 400 marks. Now kindly see 86. It is not for entry as an apprentice. It is for engagement of apprentice. Kindly see 86 for one more moment.
Yes, sir.
Paragraph number 2, 3. I am sure my learned friend would not be canvassing that for a person to enter into apprentice, the railway conducts a written examination, etc. So therefore, this has to be understood in a different perspective. Kindly see paragraph 2 at page 86 for one moment, my lord. It is further found that the paper setter and evaluator for the exam are done by the supervisor staff. There is no such provision under the railway rules wherein the supervisor can be assigned such roles. The paper setter and evaluator, etc., should be at least junior scale officers. The marks and attendance of the candidates are uploaded on the apprentice portal, etc. immediately. The access should be restricted to one person. Then, after completion of the examination of railways, the marks are uploaded on the website for which certificate generated from the apprenticeship portal. No approval of HOD is required. So, all these talk of after completion of training, not entry into apprentice. This is one thing. And second thing is, the second aspect which I have to reply is 20%, 21 centers. You have applied for Southern India, you have applied for Kashmir. They are totally irrelevant. In as much as the prayer was, your lordships would be agreeing with me, for an unemployed person, place of his normal residence will best jurisdiction in the High Court where he can knock the doors of the court for the redressal of his grievance. So, all the persons who are now petitioners before your lordship are within the territorial jurisdiction of this court. And they pray, I may have applied for post in Punjab. If I have a preference, I may apply. But as of now, I am not an employee in Punjab. As of now, I am not employed in Southern region. I am only a person unemployed applying from Hyderabad. Therefore, within the territorial jurisdiction of this honorable court. This is the precise reason why I said we need to get that act also, saying that he applied for Southern region. And the third aspect which my learned friend read to your lordship, the 2019 order of the Honorable Central State Tribunal, that's a case where their names were included, subsequently deleted. Consequently, the DGP order was not in challenge there. My inclusion in the panel and removal from the panel was a subject matter of challenge. Therefore, the counsel for the petitioner who incidentally filed this rightly went to that court. The counsel for the petitioner who incidentally filed that court came to this court specifically expected of a model employer. We are no longer model employer. If they say we can't help it. But question is, will you not address that question first? Does it not mean that your anxiety is to get the post? And kindly see the
ticket application has been filed under the third respondent only. Keep it open for the filing of counter under the first respondent. This matter of some time. The matter reserve to the extent of the interlock application filed by the respondent will pass orders. Yeah. So for IAs are concerned, will pass orders.
result is super.
IAs are concerned. I will pass an order. Leave it open for the for filing counter on the
Unless the DGT let us come, your lordship cannot find it.
because interim orders to the extent of respondent three only they filed a counter. Will pass orders to the extent of the wicked application of counter. It is open for the Marsim Sharma for file of counter. Counter on the first respondent.
The judgment of the division bench of the Honorable Court held in first court relating to 2019 election, where also, my lord, the DGT has not issued certificate. The court they came to this court and said certificate will have to be issued and consequently appointment will have to be allowed.
Yes. What is it?
What is undertaking what they're saying is the petitioner in above petition undertakes that he shall not alienate, encumber, transfer, or create any third party interest in all the properties which are mentioned in the request. That is exactly the purpose of attachment.
For his satisfaction, what is this, sir? I do agree.